As Your Honor knows, after the evidence is closed, if there's a failure of competent evidence tending to prove the charge in the indictment, then the defendant is entitled to a directed verdict. The court should consider only the existence or non-existence of the evidence and not its weight. In this case, Your Honor, the evidence is exclusively circumstantial, and in State v. Dent, the South Carolina Court of Appeals in 2021 explained that the standard to be applied when the state relies upon circumstantial evidence is that all of the circumstances must be consistent with each other and when taken together point conclusively to the guilt of the accused beyond a reasonable doubt. If their circumstances merely portray the defendant's behavior as suspicious, the proof has failed. And also another legal doctrine that we would point out is mere presence at the scene of a crime without more is insufficient to constitute guilt. The reason I say that legal doctrine, Your Honor, is at most what the state has proven and offered of proof is that the defendant was at the kennels at 8:44. He misstated that he was there, or he lied about he was being down there, and that raises a level of suspicion, and that they have concocted a cell phone timeline to come up with a time of death without any actual evidence of time of death. And there is no direct and frankly circumstantial evidence presented that the defendant shot and killed his wife Maggie or son Paul. As the evidence established, the murderer would have had blood and biological material on him or her. The murderer would have had blood on his or her clothing. The murderer would have murder weapons. The murderer or murderers would have evidence of disposing of murder weapons on property or vehicle. And there's no evidence that Alex Murdaugh had any of this. He had no blood from the brutal murder of his son Paul. He had no DNA from Paul on his clothing in an area where you would expect to find it if he had shot his son, which he did not. There's no GSR on his clothing or clothes that is inconsistent with Alec holding a shotgun for protection. The state has proven at most that he was at the kennels at 8:44 p.m. The state does not have proof of time of death. The state does only have proof of when the last time Paul and Maggie used their phones. Most importantly, and as I mentioned earlier, the law is clear. Mere presence at the scene of a crime is insufficient to establish guilt. Although, to be equally clear, Alex Murdaugh was not at the scene of the crime at the time his wife and son were murdered, and there's no evidence that he was. And for that reason, we move for a directed verdict.
Yes, sir. By the state.
Your Honor, looking at the evidence that's been presented by the state, first of all, without detailing every bit of evidence, there's been ample evidence of motive evidence presented in this particular case. The years of embezzlement and theft and the exposure, very significant exposure that the defendant was facing as June the 7th approached, would include the loss of a job, the loss of a career, the loss of his bar license, the loss of years of wealth, the potential to lose everything, in his own words. You've heard evidence about a confrontation June 7th on those matters that very day, as well as the boat hearing that was upcoming. And the effects that would have. Also heard extensive evidence of the defendant's financial condition on that day as it moved forward. Also evidence, Your Honor, of his ongoing narcotics addiction and how those particular things were relevant to what was going on as it related to the victims. There's been evidence, and again, as Your Honor is aware, the evidence must be taken in the light most favorable to the state, that family weapons were used to murder Maggie and Paul. You've heard evidence from the defendant's own mouth about a missing shotgun, and of course we have extensive evidence about the missing blackout, that being the replacement gun. Of course, you've heard evidence that the defendant claimed that was missing at Christmas time, but there was evidence from Will Loving that gun was present and being used, including at the side of the house as late as turkey season, just a couple months prior to the murders. And that from the firearms expert, that the cases found around Maggie's body were cycled through the same weapon. The murder weapon cycled the same cases as weather cases that were found at the side of the house, consistent with what Will Loving testified, as well as at the shooting range across the street. You've additionally heard that the same exact brand and weight of ammo that was used to kill Maggie was found throughout the property. as well as the same buckshot and birdshot ammo as well. There's been evidence presented by the state as to the defendant's trip to Alameda and his interaction with Shelley Smith after the murders, as well as the bringing the raincoat in. Additionally, that he left and moved his dad's truck in the four-wheeler, and that the raincoat contained high levels of GSR. There's been evidence presented in this particular case inconsistent with the defendant's statements to law enforcement, multiple changes of clothes that particular day, as well as evidence from Blanca that the clothes that he was wearing in the Snapchat video were never seen again, as well as the fact that the earlier clothes that he was wearing were not seen either. You have evidence that the defendant claimed that he was unaware that Maggie was coming to Moselle, or he did not ask for that, but you've heard evidence from multiple sources, including a text message that he specifically asked the victim to be present on that day. Your Honor, he was found in possession of a shotgun that cannot be excluded as a murder weapon that also had Maggie's blood on it. And then, of course, Your Honor, we have extensive phone and other digital evidence, and I don't need to reiterate the last witness, but that's been presented from multiple witnesses and multiple sources of a timeline. The defendant, of course, claimed that he was never at the scene, and the evidence shows, pursuant to the state's theory and reasonable inferences therefrom, that he was at the scene, contrary to what he told everyone who would listen. Just minutes, he's at the scene with the two victims, just minutes before, under the state's theory and a reasonable inference from the evidence, the victims were killed. Additionally, his conduct in the timeline after that, there's a number of reasonable inferences about that are consistent with the defendant's guilt. And to summarize a month's worth of evidence, that is the summary. But happy to address the timeline more, but I know that Your Honor just heard it in great detail.
There's a motion for directed verdict that's made at the end of the state's case. The court is concerned with whether there is any evidence, either direct or circumstantial, which reasonably tends to prove the guilt of the accused, or from which the guilt of the accused may be fairly and logically deduced. In this case, we have had, is it day 20 now? I guess 18 days of direct and circumstantial evidence. And the law makes no distinction between the weight or value to be given either direct evidence or circumstantial evidence. Nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. Cases can be proven by direct evidence, circumstantial evidence, or a combination of the two. At this stage of the proceedings, there's evidence to support a guilty verdict if it is believed by the jury. I therefore deny the motion for a directed verdict. Ready to roll with the defense?
Rock and roll, Your Honor.
Rock and roll. All right, well, let's take a 30-second stretch and bring the jury out and press.